Welcome to the jurisprudence taught by Dr. Peter Onyango Nyoyo from the University of Nairobi Faculty of Law. Today's lesson 10 is on the legal positivism and analytical jurisprudence. We have dealt in the previous video series with the analysis of the initial stages or the history of the jurisprudence, beginning with the definition of the jurisprudence, its historical development, and remember, by that time, the analytical definition of law has not been addressed as yet. This one is the beginning and the starting point of the analytical school of jurisprudence and the legal positivism that is introduced to us by its founder, John Austin from the University of London. Professor John Austin, who taught law at this particular university, brought a lot of contribution to what today we refer to as the legal positivism. But I would like to start with these substantive questions that underpin this course and this lecture number 10. Who was indeed John Austin? Question number 2, what was his idea about the theory of law? Question number 3, what are the loopholes in the Austinian theory of law? Question number 4 would be dealt with by the critiques afterwards. But let's look at section 10.3. Austin's theory of law, looking at the analytical school of jurisprudence, as well as the legal positivism as the theory of jurisprudence or the fundamental theory of the jurisprudence. Section 10.6, Austin is the father of the analytical jurisprudence, and he was the student of Jeremy Bentham, the utilitarian philosopher. Section 10.4, his contribution to the knowledge of law is so significant for understanding of jurisprudence in general. But remember, we are concerned with the legal positivism, which of course we are going to explain straight away. Let us, before this, look at his standing point. The position of Austin, number 1, law should be clear. Number 2, law should be systematic and precise. Number 3, law comes from the sovereign, that is the state. Section 10.5, we want to look at his definition of law as a command from the sovereign. This one brings us to the following 4 concepts that will be analyzed as well. That is, what is sovereign, what is command, and what is duty, and what is sanction. Remember that Austin's definition is based on the analysis of the legal positivism, which of course takes us to the understanding of what is truly a legal positivism. Legal positivism begins with the word, what is legal? What is legal here is what is related to law. Positivism comes from the very word of posited, because according to Austin, law has got social aspect. It is from man-made institutions, that is parliament, or an authority that is acknowledged, obeyed by the members of that particular society. Let us look at section 10.6. Only political superior, that is the sovereign. When he talks about the sovereign, he talks about the political leader, the political superior, to whom people habitually allege their obedience or give their obedience to. In this case, there must be a superior, political superior, and those who are political inferior. So the political inferior are the subjects. Section 10.7, who should obey the law? In this case, we find that obedience of the law is meant for those who are politically inferior, who habitually obey the sovereign. And that means the commands of the sovereign are equally obeyed. But there's also the question of sanction. That means the fear of sanction is what compels the individuals habitually to obey the command. But let us look at the classification of law according to Austin. How is Austin looking at the law? Because he's breaking it into pieces, that is sovereign, command, obedience, sanction, in terms of punishment. But let us look at the classification. Now, section 10.8.1. Austin is looking at the law properly so-called. Law properly so-called, that is the man-made law, the posited law. That means the aspect known as the social aspect of law. And this enables Austin to be opposed to any theory emanating from the naturalists, those who related the concept of law to the divinities, to religion, to theology, but also to the unknown circumstances or any other authority outside the law. The law must be socially constructed. That means it must be enacted by a socially accepted and established institution, in this case, Parliament, the legislature. And the members of the legislature are the legislators, whose primary mandate is to make the law, and make the law, to legislate, to abrogate the law, but also to repeal it. Now, point number 10, or section 10.8.2, law improperly so-called is just laws of analogy, for instance, laws of metaphor, and those are related and attributed to the naturalist school of thought. Section 10.9 of our lesson 10, Austin negated the theory of natural law. In this case, 1, he says no to law and morality together. That is law as it ought to be. Number 2, he refers to international law as a weak law. Number 3, law is what it is, as opposed to what it ought to be. Number 4, no concern of Austin with justness or unjustness of the law. Section 10.10, the questions of rights and duties come from the sovereign. That means it is the sovereign to say what are the rights, and it is the sovereign to say what are the duties. We are talking about the legal rights. Those are rights conferred to people by the law, and the duties imposed upon the people by the law. Section 10.11, law is wide, but the sovereignty cannot be shared. So let us say that even though the law has got such a wide space, but the power of making it cannot be shared. It can only come from the sovereign. Let's look at the criticisms under section 10.12. 1, the criticism on the idea of the sovereign. This is where the scholars disagree to Austin. Number 2, the rejection of natural law. Even here, there is a disagreement by the naturalist school of thought. Number 3, No clue. Austin has got no clue on the concept of justice. His definition does not take into account what is justice. Number 4, Austin denies the international law as a good law, and that is the reference to the international law as weak law. Number 5, he says no to customary law. Number 6, the notion of command. Command is the only source of law in the Austinian definition. Our learning outcome here is first, what is the analytical school of jurisprudence introduced and put in place or founded by Austin? What is indeed the basic elements of the legal positivism? Our learning outcome here, Professor John Austin from the University of London has made a historical contribution, and he has made achievement in sparking of a lot of debates around the definition of law, the nature of law, the authority of law, and the power behind the lawmaking process, the sovereign. The sovereign, the notion of law as command, the obedience to the law, which according to him must be habitual, and people obey the sovereign habitually, and the concept of punishment, sanctions. Law is a threat, and those who disobey it shall be subjected to severe or some kind of punishment by the sovereign. In this case, there is a lot to learn from Austin, and it's a lot also to engage in the understanding of the distinction between the law and morality. For Austin, law is what it is, what is posited. For the naturalist school of thought or the naturalist thinkers, law is what it ought to be. Thank you for watching. Peter here, and bye for now.